So today's webinar is going to cover three basic aspects of DPDP Act as well as the rules. So it would basically say where you stay, where your organization stays, and what you do, and what the processes do, and what measures you take before implementing the processes, and what are the traps whilst addressing these processes. And at last, a plan and moving ahead from Monday, how to organize yourself in regards to the DPDP compliance. So let me also share my presentation with you. Okay, so let's start. So DPDP Act 2023. So this act was a pivotal move by Indian government, mainly aimed at protecting personal data. So DPDP Act stands for Digital Personal Data Protection Act. And the recent update in this act is the implementation of DPDP rules, which was done on 13th November 2025. And just to get you into the concept of the rules, it is implemented in three phases. The third phase being implementation. We are at the first phase where we get ourselves ready for the app, as well as the government gets the regulatory setup done before it is completely established. So personal data, that is the main thing covered under the whole act and the rules as well. So when we take our legal system, like we legal teams deal with contracts and Aadhaar cards, PAN cards while drafting documents, and uh, even other client sensitive information. And in regards to HR, so they deal with the Aadhaar and PAN while enrolling the employee, and other pension and other related documentation. And in operations, they take care of customer contracts, invoices, CCTV information, vendor, and even delivery records. And mainly, IT people take care of the user accounts, IP logs and device data, access logs, and even backups. So these are the general things which come under the four main categories of operations in a firm generally. So every data, which I mean under this act, is personal data. So DPDP Act applies for digital personal data and also offline data which is being collected, which is rather being digitalized later. And this act is territorial in nature, so it is applicable to the territory of India, and it also applies to the territory out of India when the goods and services are redirect or are linked to the data principles in India. So wording wise, let me just let you know three important words. So that would be data principle. So we are the ones who are giving out the information are the data principle, and the ones, a company or a firm who collects the data, are the data fiduciaries. And such data fiduciaries might give it to a data processor who does the processing and getting the consent work for the data fiduciary. So even though they do the processing work, data fiduciary is the one liable for the data. And let's also start with MSMEs. So this is where this part of the presentation is where you know where you stand and where the organization stands. So MSMEs make, like, we are too small as a myth. So the act does not cover MSME blanket exemption merely because the head count is low, or even a 5% recruitment firm with thousands of CVs, they fall under this act. So the more you handle personal data, the more you get under the hold of this act. So government might notify exemptions to MSMEs, and even might notify that significant data fiduciaries may get extra obligations, but it is not identical for every case. But we are too small or we are an MSME does not by itself make as a compliance strategy. Rather, all the data must be processed and handled in a way which is compliant with the Act, rather than taking MSMEs as an exemption. And basically, if you hold personal data, you are in the scope of this act, and that is the key takeaway to MSMEs in this regard. And in regards to why we are supposed to start preparation now is because, as mentioned earlier, DPDP rules are being phased out in three phases. The first one being the foundation and regulatory phase, where so to your idea, rules or DPDP rules consist of 23 rules. So in the first phase, which we are at right now, the foundational phase, rules 1 and 2 and 17 to 21 are being active. So this setup makes sure that us data fiduciaries and data principals get ready, as well as the regulatory board, the Data Protection Board of India, gets their regulatory setup in hand before the implementation comes into place. And the preparation period is not merely a waiting period, rather than we are supposed to take precautionary actions and the relevant actions to make firm compliant to the act, because this might attract penalty up to 250 crores, which is the failure to take reasonable security safeguards. And in the other cases, or breach intimation failures carry penalties up to 200 crores. And separately, breach intimations in regards to children related matters also carry a scope of a separate penalty up to 200 crores. So that should be watched. And so responsibility follows decision making. As mentioned earlier, there are two main people apart from data principal who are us giving the information. So data fiduciaries do process the information and take the consent of the relevant data principal and process the information, where if needed, a significant data fiduciary is identified as one who holds heavy loads of personal data as well as heavy loads of consent getting from data principals. So in such cases, they subsidize it to a data processor who does the processing of consent as well as the data processing on regard of the fiduciary. But the basically the scene is that the same organization can hold different roles in different activities. So a CA firm, for example, processing payroll strictly on client's instruction, may be a processor for that activity. But while the fiduciary owns its own employees here, employees, billing contracts, and even the marketing lists. So this act allows the processor to be engaged only under a valid contract, but the fiduciary remains responsible for the processes carried by the processor on the fiduciary's behalf. So it is merely a contractual obligation between those two, but here the responsible person is the data fiduciary who collects the data from us, the data principal. For example, even a cloud HR platform does not become responsible for deciding why the employer collects KYC documents merely because it stores the files. So that is why we need to practically prepare ourselves for the compliance of this act. And the part two of this presentation would cover what to do about the preparation activities for the compliance and what are the traps in this scope. So this would be the readiness framework. Uh, so the owner, the one in on behalf of the data fiduciary who collects the consent and the data from a person, a data principal, must be identified. Then we should map the data as to what personal data do we hold and where does it move? Because as mentioned earlier, DPDP Act is territorial and applies to the inside India. So such data must be stored inside data and in the servers inside India. When it moves out, the obligations change and the applicable act changes. So that is something to consider. And number three, purpose. So why we are processing such data and what legal statute supports that purpose is a must. And four, notice. So we are supposed to give a notice to the person as to why we are collecting the information, what information is being collected, and how such information is being processed and where is it stored. And also such notice should contain clarity as to reversal of consent as well as redressal, whereas redressal as to the contact information of the data protection officer, if in case they want to withdraw their consent and other related matters. And 5 vendors. So, which vendors are here and what information do they receive must be tracked. And retention. So, how long should the record remain with us? And this is decided based on the firm or whatever the reason the information is stored on. And 7 is the response. So if the data is lost, altered, or disclosed publicly, who acts and by when do they act is must. So these are not 7 just policies, but these are 7 essential questions. So if your organization can answer them with evidence for each major process, your compliance program becomes real. So a single customer onboarding for a company, take our legal firm, Unimarks Legal Solution. So if we take a client onboarding, we are supposed to notify the client of what information we collect, why we are collecting it, and where we are storing it, and if we are using any vendors in the process, and if we are retaining the information even after the contract or agreement between us expires, and for what reason. And mainly the response strategy too. So that is a must in every case. So the response as to how quick we are addressing the action plans proposed for any loss of data or breach of data, and as well as informing to the relevant protection board as soon as possible. So moving on to the map of the data journey. So despite these questions, one must start with mapping the data inside their organization. So the core idea is to find out the exit triggers and retention purposes and follow the law here. So to take an employee's life cycle, you should recruit. The process of recruitment is going on there. Onboarding is there. Payroll, benefits, performance, and exit. So this is where when we are asking the employee to leave, we don't delete their information right away, like given their Aadhaar card or any other KYC information. We're not supposed to delete right away, or it does not apply that we delete it right away. We retain the data which is relevant to us, such as employment, PF, ESI tax documentation. So this is for us to keep it for our own documentation purposes. So we collect the data, use it, share it to the relevant departments, store, and we remove it when needed or delete it when needed. This result would make a clear idea as to what data is collected, why is it stored, where is it stored, and when it is retained and deleted as well. And so moving on to the traps. So consent isn't just merely the checkbox here, like the only thing mandatory here, because consent varies. In cases of a child or a person with disability, their concern must be with a parental or guardian advisory. And the lawful route becomes mandatory or valid more than the checkbox. The Act permits processing on consent for a certain legitimate uses. Where consent is used must be free, specific, and must be informed, unconditional, and through a clear affirmative action. And such consent must also be easy to withdraw, as easy to give. And the notice which we are giving to the data principal should say in clear language as to, as mentioned earlier, what data is collected, what specified purpose is it collected for, and how such person or data principal can withdraw the consent and exercise their respective right and complain. But do not force consent into every HR processes. Like Section 7I contains employment related legitimate use grounds. So when an employee wants to access the tax documentation or KYC documentation for the employer's purposes on behalf of the employee, they don't need to get the consent from the employee for these matters. And any actions related to child protection services, benefits, or service issuance, and even child email creation, and even child real-time tracking, the tracking apps which we use with our kids, and anything which blocks harmful content to the child. The child can do such consents without their guardian or parental approval in this case. So this accounts to the statement being that consent isn't a mere checkbox. It is only one part of the application here. And trap two, so yeah, in case of vendors, they do not absorb your entire risk, but and outsourcing processes does not outsource accountability. So this was as similar to the data processor, which I mentioned earlier, where data fiduciaries hire them to process the data. So a vendor can host the data, send emails, or run payroll, but it cannot make the fiduciary responsibility disappear. Before onboarding, identity of data and purpose, and restricted use to documentational instructions and other security requirements require prompt incident escalation, assistance with rights and deletion and exit. So then the test whether the clauses operate. Can the vendor tell you whether the copies and backups sit, and can it notify you fast enough for your own legal clock? So these are all the responsibilities which the fiduciaries hold. Whether they just have a contractual obligation to the vendors who do the job for them. So as mentioned in the slide, outsourcing processing does not just outsource accountability here. And the trap number three is to have a plan before the breach. So a personal breach is an unauthorized processing or an accidental disclosure, I would say, of your personal information, even in the open internet or whatever in this case might be considered as a breach. So once the relevant DPDP provisions commence, the board must receive initial intimation without any delay, like as soon as possible as the breach is being discovered, followed by a detailed report as to how this breach has happened and what action plans have they taken within 72 hours. So, us being an organization or a startup, we must prepare ourselves to find the breach as soon as possible and make sure that we have the report ready to give to the relevant board within 72 hours. So, in a case where we hire a vendor here, and if he, you know, uh, when he accepts to give the report within 70 or 72 hours to you, you're supposed to intimate that from your end right away. So when you're set up in vendors yourself on this regard, you must make sure that you get the notification or the action plan from them for the 72-hour report in a day or two, so that you are free to give your report from your end after your revisions to the Data Protection Board of India. So moving to the next slide. Retention and exit is a trigger to review. So, as mentioned earlier, the data retention part is again being discussed here. So, we'll move to the main preparationary part. So, from Monday or right away, here's a workable first month plan for you, a 30-day plan. So, week one, appoint a cross functional owner and choose a process for which they are identifying it, perhaps employee onboarding or customer inquiries or even vendor onboarding. Week two, map its data. So, why the data is collected, the purpose, and the notice part of giving it to the data principals, and the clarity to give to the data principal as to withdrawal of consent, as well as the redressal part. So, week three, fix the highest risk gaps, like wherever notice the main part where risk appears, and other unnecessary fields, access, vendor clauses, retention triggers, and deletion clauses in your contracts. So week four would be the response part. So run one incident tabletop or simulation. So you would you should be able to deal with such incident within 6 working hours, so that you would be able to give a right action plan to the relevant authorities right away, as well as inform your breached affected person here, as well as uh, you'd be able to give a report to the authority within 72 hours and get a workable action plan here. So this is the main ideology here. Like, you map the owner, map where the data is going, what purpose such data is being used, give the notice to the relevant data principal. If vendors are there, identify what data is being given to them and what role do they play. And if needed, what data is being retained for what reason, and the responsive data is being breached. So these would be the key aspects which you should look through for the coming month, so that you get yourself en route to prepare yourself for the act which comes to complete effect on the 13th May of 2027.